S.R. Bommai versus Union of India, 1994. Is the power of the centre, that is President of India, to dismiss a state government absolute? Whether the presidential proclamation under Article 356 justiciable? And if so, to what extent? S.R. Bommai case is related to the proclamation of emergency under Article 356 of the Constitution. The case also dealt with the power of the President to dissolve state legislative assemblies and the issues relating to federalism and secularism as a part of the basic structure. To put an end to the arbitrary dismissal of state governments under Article 356. It was also held that the proclamation under Article 356 Clause 1 is not immune from judicial review. Introduction. S.R. Bommai versus Union of India case is a landmark case related to the proclamation of emergency under Article 356 of the Constitution. The case also dealt with the power of the President to dissolve state legislative assemblies and the issues relating to the federalism and secularism as a part of the basic structure. S.R. Bommai was the petitioner and the Union of India was the respondent in the case. Background. S.R. Bommai was the Chief Minister of Karnataka between 13th August 1988 and 21st April 1989. The President of India on 21st April 1989 dismissed S.R. Bommai government on the grounds that the government had lost the majority following large-scale defections and imposed President's rule in the state of Karnataka. S.R. Bommai sought an opportunity to test his majority in the assembly, but the then governor of Karnataka, P. Venkatesh Subbai, refused. Bommai filed a writ petition in the High Court of Karnataka against the governor's decision to recommend President's rule. The High Court dismissed his writ petition. He then moved to Supreme Court. The validity of these proclamations was challenged by the writ petitions in the appropriate high courts and later withdrawn to the Supreme Court. S.R. Bommai case took almost 5 years to see a logical conclusion. On 11 March 1994, a 9-judge constitution bench of the Supreme Court issued the historic order. Arguments. The main argument against the order was that the power to issue a proclamation under Article 356 is not on subjective discretion or opinion, but on objective facts. The petitioners also argued that the proclamation must provide the grounds and reasons for reaching the satisfaction, supported with the materials or the gist of the events in support of it. The counsel for petitioners strongly refuted the idea of secularism. According to them, it is a vague concept not defined in the Constitution and hence cannot be a ground for taking action under Article 356. On the other hand, the Union of India argued that the ground to issue the presidential order is the subjective satisfaction of the President, and it is in his direction and opinion to dissolve the National Assembly. It was contended on behalf of the Union of India that since the proclamation under Article 356 subclause 1 would be issued by the President on the advice of the Council of Ministers given under Article 74 Clause 1 of the Constitution, and since Clause 2 of Article 74 bars inquiry into the question whether any and what advice was tendered by ministers to the President, judicial review of the reasons which led to the issuance of tile proclamation also stands barred. It was correspondents contended that secularism being a basic feature of the Constitution, a state government can be dismissed if it is guilty of unsecular acts. What is Article 356? When Article 356 was being discussed in the Constituent Assembly, Dr. B.R. Ambedkar thought that this provision would remain a dead letter to the Constitution. 356 was, however, it has to become one of the most misused provisions in the Constitution. Sakaria Commission on Center-State Relations recommended that Article 356 should be used very sparingly. The Punchi Commission on Center-State Relations recommended that principles laid down by the Supreme Court should be followed when applying the President's rule.